Well, good morning, everyone, and thank you for standing with Priests for Life, with the Archdiocese of Washington, with Catholic University of America, with Thomas Aquinas College, and with Dr. Alveda King, Janet Morana, myself, all those who are plaintiffs in this case. And thank you for standing with all those who are plaintiffs in all the religious liberty cases responding to this HHS mandate, which are at various levels of the courts. Once again, to make clear, today, this morning, what just happened, the oral arguments that just now concluded in our case, is the first time that the merits of these arguments have been presented at the appellate level. So this is another step forward for all the religious cases. As we know, a few weeks ago, the Hobby Lobby case was argued at the Supreme Court, and that represents the arguments and the objections of the businesses that are subject to this mandate. And I was in communication with David Green, the CEO of Hobby Lobby, and he and his family, of course, are standing in union and solidarity with us today, because although the facts and arguments are different, at the core, there is one essential thing we all are saying in common: that we will obey God rather than men. When it comes to an unjust requirement of the law that causes us to be in the choice of having to either violate our faith or be subject to penalties from the government. That is a substantial burden on religious freedom, and the arguments that we just made inside were very simple, and our chief legal counsel will comment on this in more detail in a moment, but very simply that the government may not do that. No law may do that under the Religious Freedom Restoration Act, under the Constitution, under human dignity. You have the freedom to live your life in the way you believe God requires you to do so, and that doesn't just apply to church on Sunday morning, it applies to what you do at work on Monday morning. Let me just make clear also that we are not here today begging the court. We are here today making the arguments which were made just now very, very well, but we are set in the conclusion. We know what we are going to do and what we are not going to do. There's no way that we can cooperate in evil. So we're not here begging the court for anything. We're here asking the court to hear the arguments and to make the right decision. Now, as far as how the oral arguments went right now, as a non-attorney myself, but as someone very familiar with the arguments in this case, I found the three judges, and we had Judge Rogers, Judge Wilkins, and Judge Pillard hearing the case this morning on this panel. I found them to be very even-handed in the kinds of questions they were asking. They pressed the government very, very hard, because essentially the government is saying to us, well, you're saying it's a substantial burden, but we don't believe it is. Whether the government believes it is or not doesn't matter. It's the believer who believes, and it's the believer who has the freedom. So it's not up to the government to start parsing religious doctrine or telling us which ones apply and which ones don't. Obviously, the court has a role. Obviously, the court has a role to determine whether a burden is substantial or not. But the starting point is, what does the believer believe, and what does the religion he or she belongs to teach? And that has been made clear. That cannot be called into question. And we believe this morning that the case was made. And I personally am happy with what I heard in terms of the questions that were asked. And really, that's all you can come away from in an oral argument. What was the direction of the questions? You can't predict the outcome of the case. And now we are going to continue to ask our supporters, we're going to continue to ask all believers to keep up the prayers, and we have the prayercampaign.org website for continued prayers against the HHS mandate, again in this case and in all the cases, and likewise for us to continue to press the arguments, whether it's in discussions with our families and co-workers or blogging and social media, in any way and every way we can, because this is a crucial moment. As I said when this case was argued at the district court level, this is a battle of biblical proportions. In the Old Testament, we see the example of when Antiochus Epiphanes tried to force the Jewish people to adhere to standards contrary to their faith. We see the stories of martyrdom. We see Eleazar, the old man, refusing to eat pork. And people could say to him, well, why don't you just eat it and get it over with, and you can save your life? Or why don't you bring meat that's okay for you to eat and just pretend to be eating the pork? Satisfy the government and then get on with your life. And he said, no, I cannot disobey the Lord. And then when Christians were persecuted, it was just, well, just put a little bit of incense in the fire and say Caesar is Lord. Then you can get on with your life. It's a small act. It's a simple thing. And they said, no, we cannot violate our loyalty to God. And today the court is saying, the government is saying to us, well, why don't you just sign a little form? Says you object, and your insurance policy won't cover these objectionable practices. And we say, but that still involves us in the government's plan to expand access to abortion-inducing drugs and contraceptives. We don't believe in that scheme, and we're not going to participate in it. Now, if the government wants to go ahead and give people that coverage anyway, let that be on their conscience, not ours. The whole point is we don't want to cooperate in the scheme. So exempt us from the mandate. That's what we demand. That's what we'll continue to demand. And we stand in the great biblical tradition and Christian historic tradition of loyalty to the demands of God over and above the decrees of government.